the first to know. Nsem-Pii TV.
You are for your baba Nsem-Pii TV. So, and ye kwako PM our Parliament House. Na Parliament House Special Committee, Appointments Committee, set up by Parliament or more vetted. Nominees are President of the Land, His Excellency Nana Addo Kwofie, and nominated Omonko serve as Supreme Court Justices. Now, this particular individual will serve as President of Judges and Magistrates from 2021 to current date 2023. If any Justice Kwofie. Now, interesting, what's now on the case I also some years back. Judges be ye omo free idea so. Judges in the Justice Ringo, Justice Charles Quest, and a Justice AEC Ato. Interestingly, sa judges way na Anas Aremeya Anas ne famous investigations ye some issues of corruption by the judiciary shaking the foundations of this country. Sa particular judge we eka 5-member committee or maintenance say share the evidence against these judges and on the ruling by and honorable Suhini, member of the opposition NDC. Ebusa said Judge B currently akase Anas a investigative terrorist or some sort extortionist or share the facts of the case or share some nipa we any evidence and original so these particular judges again and work for the judge na can for Anas Aremeya Anas so investigative terrorist in the particular case with Honorable Kennedy Japan and currently we share some years back original Anas we swan investigations Justice Charles Quest and a Justice IEC Ado only ano ni interested Supreme Court judge we a judge obetimi akwakotina the Supreme Court bench so before then we some questions be ano but you pay attention to the well ye Anas Aremeya Anas question.
Jurisdiction of the court, actually.
Okay, my lord, I also see on page 3 of your CV that as part of some of the leadership or committees that you served in, you indicated that in 2016 you served on the Article 146 committee for the impeachment of Justice Ringo, may his soul rest in peace. 2017 for the impeachment of Justice Charles Quest, and the committee for impeachment of Justice IEC Ado. You also earlier in an answer to a question said that some of these or many of these were as a result of the Anas Aremeya Anas investigation. Now, based on the work of Anas Aremeya Anas, you served on these committees and recommended the suspension of some of these justices. Recently, a colleague judge described the work of Anas Aremeya Anas as investigative terrorism, called him an extortionist, a blackmailer, and evil. How does that make you feel, knowing that based on his work, that is now described as investigative terrorism by a colleague, you recommended the dismissal or suspension of some of your colleagues?
Thank you. Honorable Chairman, I know that that judgment you are referring to is a subject of appeal. I know. It is even the subject of a judicial review application before the Supreme Court. So I will not be drawn, I do not want to be drawn on that issue. As to how the judge described that, I don't want to go there. Because it is the subject of a judicial review application before the Supreme Court, and it's also the subject of appeal at the Court of Appeal.
But, my lord, the real issue is based on the work of that person, cut out the description, you recommended. What was the basis of your recommendation? Did he bring evidence that supports the law, or that? I think that should be where your answer should be.
One of the cases has nothing to do with Anas Arimiyao. The case of Justice Ringo, the one honorable member Ringo Kas Azuma, had nothing to do with Anas case. The two, Justice Charles Quist and Aisi Ado, had everything to do with Anas. But you see, a petition had been sent to the president. It had been forwarded to the Chief Justice, who had, as mandated under Article 146, done a preliminary primary investigation and come out with a primary facie case against these judges. And then based on that, the Chief Justice then constituted this 5-member committee, of which I was a member. These judges, Charles Quist, especially Justice Isiado, he chose not to appear before the committee. So the committee dealt with the evidence before it. And we, based on that, recommended that he should be removed as a judge of the High Court. The same goes for Justice Charles Quist. He gave a power of attorney to the wife who gave evidence before the committee, and based on the evidence and the evidence before the committee, we found that he determined that they should be removed. The 5-man committee determined that they should be removed.
So your position is that the evidence presented before you as members of the committee did not suggest that it was procured through evil, blackmail, and all that.
Honorable, please don't answer that one. His answer is sufficient. Those are your imputations, please. That has nothing to do. Please ask another question.
I know. Sometimes it's important we get educated and get the separation, right. But I'll move on. So he dealt with a separate evidence. What is before the appeals court may not be related to the evidence that he dealt with. But I'll move on. As president of the Association of Magistrates and Judges, I came across what seemed like a media bliss on how to interpret interpret and understand what Article 71 office holders get every 4 years. A statement was issued. Many news outlets carried it to say that justices of the Superior Court do not take ex gratia, and that what they benefit from are properly so-called back pay or salary arrears. Now, he issued that as a president of the Association of Magistrates and Judges. Now, that seemed to be the confusion in the minds of many when it comes to Article 71 office holders. And sometimes, because as members of Parliament, we stand to be elected, we find it very difficult to speak for ourselves. But does what the judiciary benefit from differentiate from what the politicians benefit from? That is those who fall under Article 71. What do you think about the discussion around the need to repeal that provision of the Constitution?
Honorable Member, you refer to a media blitz. That statement that was issued was actually in reaction to what was discussion that was going on that week about judges. In fact, they were specific. Judges taking ex gratia every 4 years. And that is what necessitated us to come out with that statement to say that judges do not take ex gratia every 4 years. And which is the correct position. As I sit here now, I am on 2020 salary. I don't know about MPs. I don't know about MPs, but as I sit here, I and all my colleagues take on the salary determined by the committee that finished its work in 2020 and came out with a salary. So as I sit here, including Her Ladyship, the Chief Justice, we are all on 2020 salary. 2021, 2022, we are in 2023.
Not even cola.
Honorable member, you know that some people took cola. We haven't taken anything. So next, I know the president has set up another committee as required under Article 71. Now, if the committee comes out and says next year that in 2021, because obviously it has to start from 2020, in 2021, what you should actually have taken was this 5% over what you were taking in 2020. In 2022, 2023, 2024, that is how the progression is done. And then the difference is paid to me. That is what I should actually have taken. I think if we want to do it the right way, we should forget about this one,
my Lord,
and pay ourselves every year.
My Lord, you are preaching to the converted in this matter. We are all in the same super zone.
I'm very careful. I don't know about what MPs take. To be honest with you.
No.
My Lord, you know that.
Mr. Chairman, so that is why I asked the question. Does what pertain with the judiciary, is it different? Is it different, per your knowledge, with what pertains with politicians? Because the thing is 71, and we are all 71, Article 71 office holders. So I like the way you have explained it. And like Chairman has said, it is the same thing that politicians also go through. And it is the same payment that is paid to the judiciary, that is paid to the politician, which is described as ex gratia. As members, it's the same calculation that is usually done. But I'm saying, if we have come to if you agree with me that what pertains with the judiciary is not different with MPs, and they're actually the same, what do you make of the discussion around the need to repeal that provision of the Constitution that they say gives Article 71 office holders special treatment, so-called special treatment?
You see, I'm very careful about, I don't want to wade into your conditions of service, because I don't know, in all honesty.
But it is covered by Article 71. It cannot be different. 71.
My Lord, Article 71 regulates all of. There are differences, though, yes, because we are contract employees and our term ends every 4 years. They continue and they're progressing and so on. So let's not hold on to what he may not know.
I don't know what you take.
That's right. Thank you. Honorable Kwofie.
It is 6 to 87. I was actually doing. It is 6 to 88. I was actually doing. I think it's an error. I was doing national service.
Okay.
It is 6 to 88 June. I was a national service person.
Okay, so that is not provided here. I'm sure that it will be helpful if you make that provision. Now, my first question. If you look at the letter that the president sent to Parliament, a number of things come to attention. The first paragraph, the last line, the president says there are now 13 justices of the court, including the new Chief Justice, Mrs. Justice Gertrude Tokono. That's the last line. And he's nominated these 3. Now, that will bring the number to 16. Because that's why, if you notice, when my colleague was saying 15, I said 16. Because the last line in the first paragraph says, there are now 13 justices of the court, including the new Chief Justice, Mrs. Justice Gertrude Tokono. No, the president indicated that these vacancies have occurred as a result of the mandatory retirement of Justice Nene Kwofie Amegache on 3rd February 2023, Chief Justice Enin Yeboah on 24th May 2023, and Justice Jones Doche on 8th June 2023. There are now 13 justices of the court, including the new Chief Justice, Mrs. Gertrude Tokono. So, that's not really my issue. My issue is that in the second paragraph, he says, in order to fill these vacancies, enrich the full complement of the court, and the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. Have we established a full complement of the court? And what is deemed as a full complement of the court that the president has to nominate these 3 to fill up?
Honorable member, I don't know the date of the president's letter.
23rd October.
I know that in October, another justice of the Supreme Court has retired, Professor Kwofie. Probably that explains why Professor Kwofie has since, in fact, in October, he has retired as a justice of the Supreme Court. So probably we need to look at the numbers. But talking about full complement, I think for now, the convention seems to be around 15, 16. I think that's all that I'll say for now.
Okay, so so the president could have chosen not to appoint any more to replace these people. My issue is when he says that he needs to reach the full complement of the court, as if to suggest that there's an established number that should not be below, because the established number by the constitution is that it should not be below 9. And so even if you have 3 going and you still have about 12 or 13, what does it mean to say to fill the full complement?
In answer to a question, I did say that the constitution that talks about the 9 is the minimum number. There is no upper ceiling. But by convention over the years, we are playing around 15, around